Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Supreme Court of India, two judges bench. Justice Abhay Srinivas Vokha and Augustine George Mashi in the case of XYZ Vs.State of Gujarat. Yesterday gave an advisory, please remember, gave an advisory to all the high courts to ensure the presence of the victim in cases where quashment is given due to the compromise settlement in non-bailable cases, non-compoundable cases particularly. Why? This is very, very important. Prior to that, I will give an example. It happened in Ogun. There was a case and counter case between two parties. Of course, it's a criminal case. They wanted to effect compromise. Our client was not interested, but the villagers, his relatives, his own caste people, his community people, his political gurus, all of them pressurized him. And he said, okay, since you are coming as an elder, we as elders, I can't say no. Immediately, the elders came to the advocate and they said that you file a compromise petition on behalf of so-and-so before the National Lok Adalat to be held on so-and-so date. The advocate, believing them, he filed the compromise report, and when the matter was taken up before the Lok Adalat, that man said, no, I did not say. Then he asked the lawyer, did I tell you? Actually, the complainant did not tell him, only his relatives. It was a lot of subject of discussion. So please remember, the lawyer should consult only his client, not any other. Likewise, here, when a compromise issue comes, particularly in uncomfortable cases, you have to ensure the presence of the victim and you have to take a statement from the victim, or at least you have to orally examine the victim. This is the advisory given by the Supreme Court. Why? We will tell you. Right. This is a case, actually, I think this is in Gujarat. This is a case, FIR, registered under sections 376 clause 2 of the Indian Penal Code, as well as 506 IPC and also section 3 SC/ST Act. The charge sheet was also filed, but now not the principal accused, the other accused in this case, he sought for quashment basing on the settlement between the parties. What is the settlement? The husband of this victim, rape victim, was paid 3 lakhs rupees. Therefore, the brother of this victim asked her to put her signatures on some stamp papers, which she innocently put, and ultimately the case is about to be quashed. Actually, it was quashed by the High Court. Now she has come to the Supreme Court alleging that this quashment is not agreeable to her and she did not think that it is quashment, it is a compound, it is compromise. ఆవిడ తెలీదు, కేవలం వాళ్ళ అన్నయ్య వచ్చాడు, డబ్బులు తీసుకున్నాడు, వాళ్ళ భర్త వాళ్ళ అన్నయ్య ఏలుముద్దలు వేయమన్నారు, వేసేసింది. షీ ఈజ్ ఆల్సో ఇలిటరేట్. ఐ థింక్ షీ హాజ్ ఫిక్స్డ్ ఓన్లీ LTA, left and impression. And the affidavits, one of them was prepared in Rajkot and the other was in Ahmedabad. One of the affidavits is in English and the second one is in Gujarati language. And it does not bear the attestation by any notary public or by any advocate. So definitely this affidavit is not at all an affidavit under section 139 of the CPC or in the eye of law. మీకు సిపిసి చెప్పినట్టు చెబుతాను 139 ప్రకారం. వాట్ ఈజ్ affidavit? Affidavit is a sworn statement relating to the facts known to you or the facts which are especially within your personal knowledge. attested by a notary public. This is very, very important. Here, no advocate signed on the same. So, it's not an affidavit, it's not a settlement. So, therefore, redirected. Supreme Court said that High Court cannot blindly believe the versions of the advocate, the victim's family members. They have to examine the victim. If the victim's presence is there, they should have understood the reality. It was not done. Once again, the matter was remanded back to the High Court to decide on a particular date regarding matters. Good decision by the Supreme Court, good advisory also. All the High Courts, let us hope they will follow the same. Thank you.